I'm James Sinclair Taylor. I'm here with Sahenya and Alison to do 2 hours of looking at what a company secretary is, mainly from the perspective of what we find goes wrong, so that people, because there is a huge amount that we could talk about, and we try and concentrate on what's caused problems for organisations before. We're part of a team of 14 lawyers who look after 300 or 400 charities. And the vast majority of them are companies, and the vast majority of them are charities. And this really reflects the work that comes through the door, because, as you would imagine, people tend to come to us when things haven't gone quite exactly as they were supposed to. I realise that none of that will apply to any of your organisations, and they're all immaculately run, and there are no problems of any sort. Part of the problem that we've always faced in the law is that lawyers get used to certain sorts of names, and the charity sector likes to use whatever name fits with its tradition. So if you're an evangelical church, you don't have trustees, you have elders. If you're a professional body, which is a charity, you won't have a board of trustees, you'll have a council of some sort. You won't probably have a chair, you'll probably have a president. And it is key to doing the understanding your role to get an idea of what sort of language is being used in your, because if you move jobs, people there may use language very differently. So clearly the word directors is the correct technical term for somebody who is running a charitable company. But there are also lots of staff members who are called directors, and quite a lot of people don't like being called directors, and so they call themselves members of the board of management, and a whole range of other things. So the first thing is to identify who the key players who you as company secretary have to relate to are. And the Charity Commission is very clear. They will call the people who run your charity trustees regardless of what you call them, and that in itself leads to confusion, because you get trustees saying, I don't mind being a trustee, but I won't be a director of the company. And they sit on the board, and you've got 3 people they think are directors and 5 people they think are trustees, whereas the Commission think they're all trustees, and Companies House thinks they're all directors. And it is this drilling down and really understanding, and then transmitting your knowledge to other people within the organisation as to who people are. And then there are other names that you'll come across, obviously chair and vice chair, which mean completely different things in different organisations. Some organisations are very flat, very consensual, and the chair's role is really a coordinator. Others are extremely hierarchical, and nothing really happens without the chair's say-so. So you've also got to get used to what I might call the cultural meaning of a name within your charity. Treasurer, again, some treasurers absolutely rule the finances of an iron fist. Others, it's a pretty nominal title, and they have an oversight of a committee perhaps, but not much more. And then we come to the thing of company secretary. Well, many charities, well before they started to become companies, had honorary secretaries, and many of them have kept their honorary secretaries, but now have got company secretaries. So again, sorting out the confusion of naming and ensuring that you understand what the role is, because the honorary secretary typically had a much more limited role. Again, people like to have presidents and patrons. Quite recently we were working with a long-established charity, and the Commission came in and said, we believe that your last 4 AGMs have been improperly conducted, because your president conducted them and he voted on all the resolutions. And their analysis was that the president, who in the Constitution had a right to run the AGM, had no vote because he wasn't a member and he wasn't a director. So understanding exactly who the person is and where they sit is your job, because you're going to record it all in the Register of Directors, in the Register of Members, and elsewhere. And then, of course, many of the people, particularly the directors, will have dual roles. They will be members of the organisation and they will be directors. again, trip-up point. Very often they assume that if they join the board, they become a member. So they come along to the AGM and they vote, but nobody ever admitted them as a member, so they aren't a member, they couldn't vote. This narrowly passed resolution is invalid because people were voting for it who thought they were members who weren't. So you're here to help people not trip up a lot of the time. And if you think they're about to trip up, sometimes we're here to hold your hand to make sure that the way out of the potential fall is not too difficult. And then there are other names that crop up which cause problems. Subscriber. When you set up a company, one or more people needs to sign the articles to call into being this company. That person will become the first member. Sometimes it's nothing to do with you. Sometimes it's a lawyer who formed the company for you in a hurry. Sometimes it's a company formation agent. And very often it's someone who died because your charity was formed a long time ago. But nevertheless, this person is a member and needs keeping track of, and you need to know what your role in connection with they are. So the first job really of a company secretary is to sort out how this particular charity uses language. Later on, one will have to go on to see, having discovered what language they're using, what's their cultural idea of what these roles are, because they're very, very different for different organisations. So you don't exist any longer. You're not necessary. Company secretaries were abolished in 2006, or at least their requirement was. At that same time, a well-run company would have completely updated its articles to reflect not only the Companies Act 2006, but also the Charities Act of the same period. So some people took the opportunity and said, we won't have a company secretary any longer. Not many did, because there is a series of tasks that need to be done by someone, and it's quite useful to have their title to attach them. But as we'll see, there's no list, there's no definitive list of what a company secretary does. And many organisations choose only a very limited role for the company secretary and not a very broad one. In other organisations, the company secretary is very central, member of the board, a lot of responsibilities. So traditionally, charities had people, they call things like clerk to the governors or clerk to the trustees. And that person might well have been, in fact, the chief executive, or it might have been someone who was simply a minutes clerk. And that's one of the things you're going to have to spend some time doing, trying to find out, because your job description is likely not to be a very good guide, what are the limits of what is being expected of you in this organisation, both technically and culturally. What do the trustees look to you for? Are they looking to you for governance advice as well as getting the technicalities right? Or do they see you merely as somebody who rather quietly in the background sorts out the boring stuff that they don't want to do? So what might be within the role? Well, one would hope that compliance with Companies Act requirements and Charities Act requirements, and you'll hear later in more detail about what those are. But it doesn't follow, because quite a lot of accountants like to take on Company Act compliance, and sometimes Charity Act compliance is seen as too sensitive to be handled by the company secretary, and maybe a trustee takes it on. So you need to tease out what they're expecting of you, because the very worst thing that can happen is that somebody thinks, oh, I assumed you were going to file the annual return, I assume the report to the Charity Commission has gone off, and it's never been made clear to you that that forms part of your role. Organising director recruitment and induction is often a very, very important function in terms of making a board really good at governance. When I started being a trustee at Unimaginable years ago, people didn't do anything to get you on board. You were very lucky if you had a brief conversation with the chair, and it took you 18 months to work out what was going on and what your role was. People are much more impatient now. People also limit the time that they expect people to be trustees and directors. And so the company secretary or somebody, and it may not be the company secretary, has an absolutely vital role in devising, updating, and ensuring that trustees get their induction. Now, chasing trustees to get their induction completed, they very often do a bit, but very often they fail to carry through a carefully thought out induction program. So having someone nudging the chair and saying, you realise Mary's been here 18 months and she still hasn't met the staff of our projects, or Mary's been here 18 months and I've asked her for her statement of her interests to put on the register of interests, and she's still talking to somebody else about it and I'm not getting anywhere. Key areas which cause issues, and which again you'll hear about more later, is organising the annual general meeting. It's very easy to get annual meetings wrong, and having a diary which tells you when you need to start preparing for it, what questions you needed to have sorted out, who is retiring, where are the accounts, what is the location, what are the numbers, is the register up to date. All these things need to be thought about well in advance. Membership is a vital right inside a company limited by guarantee, and it carries rights and now carries obligations. You, as the person who runs the membership register, dictate who the members are. Any judge who's dealing with a dispute about who the members are, the first thing they'll say is, the members are the people who are written down on the register, so that if you're not discharging that function, the governance democracy of the organisation is at risk. And then there is the issues of governance support to the board. So, for example, for those of you who are in charities with more than £1 million a year turnover, there should be an external review of governance every 3 years under the Charity Governance Code. Quite a lot of boards, that passes over their heads. Is anybody jogging their elbow and saying, you realise we've never had an external governance review and we're now bigger than £1 million? Have you talked to our solicitors about getting something sorted out so that that can be done? What should we be focusing this governance review on? So there are two core regulators, obviously, who are very important to you. One is the Charity Commission and one is the Companies House. Companies House is much more passive. It is being moved towards a more active role because of the concern of people hiding behind company structures and hiding their identity for money laundering and other purposes. So you are going to find that the Companies House requirements become more strictly enforced. In the past, frankly, the only thing they really cared about is if you stopped providing the annual return for long enough, they'd eventually strike you off. We've had quite a number of our clients who, when we took them on, we always do a company search, and it's one of the things I'd be suggesting you do as a joining company secretary and a charity commission search, to see what they think the reality is, as well as what you think the reality is and what the chief executive thinks the reality is. But typically what happens is, when we do that, you find that the company has been struck off and no longer exists. Everyone is outraged. How could it possibly happen? Well, the registered office, which is something that a charity would ought to have in order to keep its records in one place, was in the home of the treasurer. The treasurer retired. There was no company secretary function. It didn't get transferred to another address. And the warning letters have gone to an empty house which used to be occupied by a treasurer. So small things, which probably fall within your responsibility, but you need to check that they do, can have very large consequences. Because in the case that I was just speaking about, we only discovered it when we were about to sign a lease for this charity, and we had to say, I'm sorry, this charity has now been placed in the hands of the Crown. It's called bona vacantia, and you can't sign the lease. We can get you back, but it'll take 9 months, it'll cost money, and obviously there was a lot of upset as a result of that. Companies House rules do change, but they change with a relatively slow pace. Charity law changes with a relatively slow pace. We've got a new Charities Act, but it's not doing anything enormously radical. It's not what we're looking at here. But charity regulation is much more at the whim of changing chairs of the Charity Commission and changing chief executives. And you need to find out who within your organisation is keeping track of that, or whether, as many of the organisations we work with, you rely on having us come in once a year and do an update for the trustees to say, these are the new things that the Commission are going to want to see your trustees doing, and these are things that they're less concerned about than they used to be. But that is difficult because it's not strictly a company secretary's role, but very often who else in the organisation is keeping track of that sort of information and making sure that trustees, in addition to meeting their full legal requirements, are actually meeting the requirements which the Commission are placing on them. And they're much more pushy than they used to be. They use things called regulatory alerts to tell you that you must do X, and to indicate that if you aren't doing X, you could be in breach, or the trustees could be in breach of their duties as trustees. So that where that responsibility sits, who is discharging it, is important. There may be somebody else. You may have a governance manager who does that sort of thing, or you may rely on someone external. So the world is full of different ways of creating a charity. And we're talking about one particular way, a charitable company limited by guarantee. But even if you arrive and are told you're going to be company secretary, don't take it for granted that this entity is in fact a charitable company limited by guarantee without doing a bit of homework. Because on a number of occasions, the organisation perhaps was an unincorporated body, set up a charitable company limited by guarantee, but didn't manage to do the transition into putting the operation wholly in the hands of the company. So you do need to just work out which of these various formats which you can use for having a charity your organisation is, regardless of what you're told. You need to have assurance yourself that that's what's going on. So I think just coming back to the centrality of trying to get two things, I think. One is the actual tasks that are expected of you listed, and it will be a growing list because you'll find the trustees will decide that somebody needs to do something and you'll get that job. And the second things is the things that you ought to be asking the trustees. Well, if you're not asking me to do this, these actions need taking. Who else is doing that? I don't want there to be an omission because it's fallen between the stools. And what they expect of you culturally. So there are company secretaries who are really nothing more than a minute secretary and simply attend at meetings. There are company secretaries who believe that they are actually part of the board and should be at every board meeting, and we get outraged calls when they're excluded from the meeting because the trustees want to have a discussion of some confidential business and say and are asking, isn't this breach of company law? Well, no. The company secretary is a servant of the board, and if the board doesn't need them to come and assist on a particular issue, then they shouldn't be there. And indeed, I have to say from practice, I think that well-run boards very typically have an open meeting, by which I mean significant numbers of staff or beneficiaries come to. They follow that with a brief meeting with the chief executive alone, so that that person can speak frankly about any difficult issues, perhaps personnel issues which are developing, or risk issues. And then finally the trustees have a brief session in which they can discuss any issues that they wish to discuss. And very different conversations. I sit through all those sorts of meetings. Very different sorts of conversations occur in each of those because of the different nature of the meeting. And I think you being aware as company secretary as how that happened, all that you technically might be concerned about was that you don't have a situation in which at a trustee only meeting in which nobody's keeping any decent notes, key decisions start being made. And then the whole thing can go to hell in a handbasket because there are increasing areas where there is no transparency of what the decision was, because the decisions of the board are its legal requirements. And if you don't know what they are, A, the Commission has got some very clear guidance about how to take decisions and minute them. B, what was decided. We've had situations where, generally because of tensions within trustees, half the meeting has been taken up with internal trustee-only discussions with differing recollections of what was then decided and whether it was a discussion or decision-making, because there was no real assertion that the sort of controls that a company secretary should ensure were in place, like good minute taking, are actually taking place across the decision-making space of the organisation. So, as I said, most of this we'll look at later on in the session, but there are many other roles which could be taken on here as well. So we looked, just to see the environment, at the range of sorts of charity structures that charities use. But then everyone thinks charities registered with the Charity Commission, has a charity number, that's it. Of course, there are charities which are accepted or exempt from registering with the Charity Commission, which are just as charitable. They may be regulated by the Higher Education Funding Council, HEFCE, or the Housing Regulator, or a government ministry, or they may be not regulated by anyone, and they're outside the stronger control of the Charity Commission, but still subject to charity law in general, still have a relationship with inland revenue and tax reliefs. The very sad among you will have a situation where you're regulated by two regulators, the Charity Commission and someone like the Housing Regulator, and that is a truly dire situation, because the Housing Regulator is an extremely effective and comprehensive regulator who regularly issues rules and then looks at how you're performing against them and gives you a rating which they then publish. So this is something we haven't had happen to the majority of charities so far, but I think it is something that is not beyond the likelihood of coming forward. So some key factors: you've got to have at least one human director. Until recently you could have just corporate bodies. You've got to have a board of directors, but there are many organisations where the board of directors and the membership are the same. So one of the perhaps key characteristics that you need to establish for your organisation is it what I would call a membership charity or an association charity, in which there's a significantly larger membership than the board, or have you got a foundation model where it's really just the board are the members and the members are the board? But do remember that just because people think the members are the board and the board are the members, you do need to delve down into the structure to see whether that's actually what is happening at a constitutional level, because organisations move forward. Traditionally, membership was very, very important, and you would find that most charities had a significant membership. That has lapsed and is steadily lapsing as people become less interested in paying subscriptions and coming to AGMs and voting on things. And more charities think that the board are the members and the members of the board. Has their constitution kept up with that change in culture that's occurred in the organisation? It's one of the things that you need to do in having a regular review or audit of your constitution. And then members themselves, all sorts of use of that word member. Sometimes it refers to somebody who's not a member at all, just somebody who's pays a subscription and gets a magazine and is not part of governance at all. Sometimes it refers to people who have limited membership, perhaps they're junior members. Sometimes it refers to people who are life members. At other times, people's membership is dependent on other factors like have they paid a subscription, have they filled in particular forms, have they reaffirmed their interest. So just because there is a membership in all companies doesn't give you much indication how that title is being used within your organisation, and you need to drill down within that. There are some slightly odd membership arrangements. We've just set up a charity to look after a piece of natural wilderness, and the people don't want to have any members. What they want is anyone who lives in the 2 surrounding parishes to be able to come along and vote. So you've got members who are members by residence, but who don't actually join their membership until they take an active part. And this is quite traditional in charities, particularly ones serving a county or a parish. Doesn't fit very well with company law, which is all about contracts, because a member is a member because they promise to pay £1 or whatever it is if the organisation goes bust. And that promise is a contractual arrangement. How does being resident in the parish and deciding to come along to the AGM fit with company law? There are some things best left unexplored. And finally, bear traps. You'll hear a lot about problems in constitutions. People very often had slightly over elaborate concerns which they wrote into their constitutions in the early days, being taken over by other groups or something, and there are all sorts of qualifying things that you need to do to become a member. Do you need all that now? Is the really the risks that your founding fathers or sisters or mothers had in setting this organisation up, do those things need clearing out? And so you'll hear about the importance of constitutional reviews. I'm not a big fan of bylaws and regulations unless you're quite big and are prepared to spend quite a bit of time on your bylaws and regulations, and you've got quite an active membership and it's quite significant. It can be helpful in larger organisations. We act with people like the Youth Hostel Association, who've got 100,000, is it, members? 100,000 members, and so bylaws are useful, but there's a job in making sure that company law and the articles are congruent, and then the articles are congruent with the bylaws, and then the bylaws are congruent with the regulations. So think if somebody says, oh, let's keep the constitution simple and put it in the bylaws, you're actually making quite an interestingly difficult drafting job for yourself. So think about that. And then there comes to be questions about, we know how articles are changed by votes of membership. How do the bylaws change? Is that the members having to vote on that? In which case we haven't saved very much. Can the board decide, or can the board only amend? I mean, it throws open a whole series of questions which can all be solved, but which don't make life any simpler. And then there are perhaps a very significant minority of organisations who don't really have a constitution at all in their own heads. They do what they did last year, and that is pretty well regardless of what the Constitution says. And very often when we're working with a company secretary, they say, well, I was told that that's what we always do. And we have to say gently, the fact that you have always called invalid AGMs doesn't mean that it's a good idea to continue to call invalid AGMs. And the fact that some of your trustees never have always insisted that they're not put on the register of company directors doesn't work very well when they are in fact company directors and there's a legal duty to put it on there. So the fact that you always do something in a particular way is not a good indication necessarily of how things should be. When I first started in the law, we created a set of articles in plain English, but over the years plain English has been eroded by the complexities of getting clarity. Somebody needs to know what everything in it means. It's not good enough to go, well, that's a technicality, I'm not clear what that means. Sometimes people have summaries produced. We produce summaries for people because they say we've got a big membership, they don't want to read 20 pages of detail, we want something that summarizes it. Again, you've got another document. You don't want someone standing up and saying, my summary says that I can do this. And the company secretary having to say, yes, but that doesn't actually reflect what the Companies Act requires to happen in these circumstances. So think about it. If you're of any size at all, you probably need to get a full legal review of your memorandum and articles or your articles every 3 or 4 years. It partly depends on the pace of change of legislation, and also how you're changing. And finally, of course, relationships. Does it reflect the way, in fact, that the various parts of this governance structure really work now? Here's some issues which go wrong. You'll be looking at those in more detail. And finally, the Charity Commission does produce much, much better material than it once did. And this is a summary from their CC3, the most basic guide to governance duties. Now, one of the things you have to find out is who does the trustees ask when they want to know, is this okay with the Charity Commission? Are they expecting you to do it? In which case, have you got access to legal advice if it's a question beyond your experience? Who does things like organising governance reviews, which are required under the Code of Governance? Who decodes that? Now, I think it's pretty straightforward, but nevertheless, I've been in many boards where this guidance has been the subject of very vigorous debate. Areas like, are we allowed to campaign? People think they know absolutely, of course, as a charity, we can't campaign. Other people know from reading the guidance, yes, we can campaign as long as we do it in a sensible and balanced way. So this guidance is very useful, and I think if you see issues coming up, it's worth you going on the Commission website and searching the particular topic and seeing whether they produce something that's helpful for you. So I leave a few minutes for questions, and then we'll have a short break. Now, during your short break, I'm going to, I would ask you to just think on the day that you got appointed company secretary, what 4 documents would you really like to get your hands on and be upset if you couldn't find? There isn't any particular, and I will ask a series of you after the break what you think you're going to do. So it's not a complete break, I'm afraid, it's a break with homework. So a little time for questions before we take a break. Yes?
Can I ask about minute taking?
Yes.
And what's off-piste and what's on-piste? So if I just give you an example of we had a difficult staff member, and there's a kind of an element of risk, isn't it? It was financial, so there's an element of risk of, you know, the Charity Commission, what's risky, what's not. Yeah. What should we talk about, what shouldn't we? We did, any decisions we made, we did have a reason, but felt like a bit of a hot grey area. Oh, sorry. There was a hot grey area, if you know what I mean, where I was uncomfortable about what I should be minute taking.
It's difficult from a whole range of issues. First of all, there is a whole employment law perspective about the employer maintaining a relationship of trust and confidence with an employee. So one of the questions the tribunal would be asking is this discussion in perhaps a full board meeting appropriate about a confidential matter of the behaviour of one staff member, or should it be being handled in a different process outside of that? Then you have the difficulty of the trustee who's angry about all what has happened, saying, I'm a trustee and I'm entitled to information. Well, I don't think we all are, as trustees, entitled to all information all the time. I'll give you an example. Charities are supposed to file serious incident reports with the Charity Commission if something bad goes wrong, a safeguarding incident. They specifically say, don't identify people in your report because we think that's bad data protection practice. If we need to know exactly who it is, then we will be telling you or asking you. And the same way that staff generally shouldn't be being identified in broad board meetings. Clearly, the rules change as you get to the chief executive and the finance director, and it's rather difficult not to. But I think there's a role for pushing it into committee. There's a role for having it into private session. There's a role for sometimes in a delicate situation not minuting it. The board discussed employment problems and came to no particular conclusion, because, as I said, the employment law implications, the data protection implications, don't fit well with the idea that the trustees are entirely in charge of the organisation, entirely entitled to know everything that's going on. And it is quite difficult to hold that line. And sometimes one of the reasons people use lawyers is you said it internally, nobody's taking any notice, you need to get an external advice and say, guys, we are advised that this would involve risk. Because if we just go around in a circle, the same trustees who is saying, I must know everything, should be reminded that they mustn't do anything that creates risk for the organisation. They're there to safeguard it. So if their pursuit of information, which is inappropriate, creates risks of claims for the organisation, they should not do it. Yeah. Yes.
Yeah. Thank you very much. James, coming from a background where you looked at governance in a corporate setting, and from the cooperative sector as well, there's quite a strong stress on the risks of executive capture and the importance of governance, and therefore the company secretary or the society secretary in supporting boards to scrutinise what the executives are doing to hold them to account. It's coming into the charity sector, it's not something I hear any conversation about. Should we be talking about executive capture ever in the charity sector?
Well, the truth is it definitely exists and happens, but the cultural difference in this sector between a small evangelical church and UNICEF or whatever are such that very different issues get discussed. So if I'm advising on the board of UNICEF, there are people who are directors of corporations, are very aware of executive capture, very aware of the role of things like audit committee and nominations committee. If you're down with a medium-sized charity which was formed by a charismatic individual who selected a bunch of their friends to be the trustees, there is huge executive capture and often huge problems as a result of that when entrepreneurial zeal gives way to inappropriate behaviour. So you highlight an important problem, and there is quite a bit of bleed across from the commercial sector that you speak about into the charity sector. So to give you an example, we talked about chairs. Now, there is an argument in the commercial sector that there should be a vice chair or senior non-executive who is not going to get executive captured by the staff. So I'm chair of a couple of charities, and I spend a lot of time with the chief executive, and we do develop strategies and thoughts and ideas together. And so I've probably been partially captured, I hope not wholly captured. And the idea is that in the commercial sector, there should be a senior non-executive who is outside that, and trustees who are concerned about the direction of the organisation can discuss with and perhaps put pressure on the chair to be a little bit more independent-minded. The Code of Governance that I spoke about before last recommended the creation of a vice chair with that role. Hasn't taken on very much. There is very few charities who allocate that sort of responsibility to a vice chair. Much more frequently, the traditional role of a vice chair in a charity has been to deputise for the chair, and they're in fact involved fairly heavily with the executives because they're supposed to know what's going to happen if this person goes under a bus. So you're absolutely right. There is an issue, there is a risk. The Commission recently highlighted it slightly indirectly in a direction that they issued after a crisis in a charity by saying trustees also fail when they don't realise the skill imbalance between themselves and the staff team, and then don't realise what the professional failings of the staff team are because they don't have anyone with sufficient knowledge and experience in their team. So people should do skills audit and then say, if we can't or don't want to recruit specialists in HR onto this board, maybe we're going to need to take some independent HR advice. If we're not going to be having a safeguarding lead on the board who really knows their stuff, maybe we're going to be having to have external consultancy report or lawyer's report on how things are going. So there are different ways of tackling it, and the Commission is alert to the fact that there are problems either with capture or sometimes it's less active than capture. The board just, everything seems to be going okay. I come to the meetings, I sit and listen for some time, I have tea with the people afterwards, and everything's okay. Am I captured or am I lazy? I don't know, sorry, yes, sir.
Thank you, James, very useful. Can I just ask you, one is about subscribers.
Yeah.
When I took over July 2009, I think we had about 3 subscribers, just a handful of members. None of the subscribers are now contactable or disappeared.
Yeah.
How do we, is there a way around of replacing or re-registering?
Do you mind if I stray onto your area?
No,
I mean, essentially, you need to, one of the things we do in a governance review of articles is to say, have you got a clean-up provision in your membership arrangements? Because traditionally, members were members for life and could only be removed if they did something wrong. Whereas actually, most members should go because they've ceased to be active or involved or don't, or haven't been heard from. So you need a provision in your articles which allows you to clear out people who you think are simply either dead, uncontactable, inactive. And how you do that, there are a variety of ways we could talk about how you do that. But if you haven't got one of those, you get this build-up of people who probably don't exist, but you haven't got any evidence that they don't exist. I don't think there's a publicly available register of deaths, so you can't even trace that.
Well, what we did was we put in the articles about if member. I'm presuming subscribers are members as well.
It's just the first members. They're subscribers because they wrote their names on the Constitution.
So we've got provision that if they fail to attend 3 or more general meetings, then the membership will lapse.
Yes.
Is that a way forward?
Yeah,
that's a way of ensuring that they're no longer members.
But they'll have notices every year.
Exactly.
And if they don't respond, every year I try to get an update. Are you still living at this address?
Yeah.
Are you still wishing to be a member? And if they don't respond, 3 consecutive years, then they are off.
That's part of a clean-up provision. That's an example
So
of
the
one.
second thing was about, we've introduced fixed-term offices, maximum 2 terms, 3 years, and our chair's term of office expires very soon. our vice chair is going on maternity leave and we don't have anybody else. So do we just pass a special resolution to suspend that? Do we need Charities Commission approval to change that bit to allow the chair to continue for I don't know, for an interim period?
Okay. There's a broader question that the sector has embraced turnover on the board for very good reasons, but hasn't found methods of recruiting people sufficiently fast to fill those spaces when turnover occurs. And you're seeing it not only in charities, but in housing associations. Housing associations have the same rule, and there's a strong debate saying this is just too quick. We can't, 6 years, we can't find new people. So I think people need to think very carefully about being ideologically correct and having short periods of maximum office, unless they're very confident, and there are organisations that are very confident of being able to fill the gaps. And finally, there ought to be provisions that allow to override in specific circumstances. Now, that would require amending the articles to put an override provision in, and we normally do say, well, let's say 75% of the board say that it's necessary to keep this person on for this additional period, and the membership re-vote them back into office, then they can go beyond their normal 3, 6, 9, 10 years, whatever is the maximum term. Good. Yes, let's take a break.
Hi everyone, my name's Alison. I'm an associate on the charity team at Russell-Cooke. So I specialise in governance and commercial matters. So that means that I establish not-for-profits and charities, review and amend articles, provide governance advice, advise on mergers and acquisitions, review and negotiate contracts, and also do some fundraising advice. So quite broad. Today I'm going to be speaking about the core job of the company secretary. We're going to cover off 3 areas: key compliance duties with both Companies House and the Charity Commission, updates to Articles of Association, and trustee induction. So starting with key compliance duties with both Companies House and the Charity Commission, there are a range of responsibilities and duties of a company secretary, and they will depend on a number of factors, including the size of the charity. Today I'll be talking about some of these key compliance duties. So the company statutory register. As James was just discussing then, the company secretary will usually be responsible for maintaining the statutory registers and the minute books for both directors and members. The statutory registers usually include the register of members, the registers of directors and secretaries, and the register of people with significant control. The Companies Act prescribes what information needs to be kept in each of these registers. By way of example, the register of members should record the personal contact details of the member, the date that they join the organisation, and also the date that they cease to be a member, if that is the case. It's really important that these registers are kept up to date. I have advised many organisations. We've gotten to the point of, we've agreed the new articles. They're all perfect, the board's agreed. Let's send them out to the members so we can get them to vote on them. Who are our members? Well, that's a great question. Let's find the members register, can't find it. So we have to go through the company records, try to piece together who the members are of the organisation, send out the notice of meeting, and have the meeting to adopt the articles. So it can be a bit more of a drawn out process as opposed to when you have kept on top of your register of members, and it's much quicker. So Companies House filings. As the company secretary, you need to ensure that the company files statutory information properly at Companies House. This includes copies of resolutions, accounts and reports, notice of changes in accounting reference date and the registered office, notice of appointments or changes in secretary or director, statement of capital, amendments to articles, and the confirmation statement. That's a statement that needs to be delivered to Companies House that confirms that you have delivered all the information for the relevant period. Similarly, Charity Commission filings. So a charity must report the following information to the Charity Commission: an annual report if the charity has a gross income exceeding £10,000 in any financial year, This is filed online with the Commission in respect of each financial year. Notice of changes to the charity's public address, notice of appointments or changes in trustee or the charity contact, amendments to articles, information about the activities of the charity, the classification of the activities, if your charity owns or leases land or buildings, where your charity operates, its governance policies, your charity's other regulators, such as a housing regulator, your HMRC charity reference number, banking and building society accounts, and your charity's financial year. One of the things that we often see is the register with Companies House doesn't match the register with the Charity Commission. So it's really important that you, when you're making a change, that you do make it across both registers. Taking articles as an example, we have advised clients in the past where they've kept all their filings up to date with Companies House, and then the Commission says that the articles haven't been amended since incorporation, which is not the case. And then you have to go back through and find all the previous certificates of passing, give them to the Commission, along with all the various amendments over the period. And it can just be quite time consuming to sort all that out, and the Commission may not be very happy with you. So moving on to updates to Articles of Association. So the rules for for a charity set out basically the charity's purpose and how it will operate. Trustees should only consider changing the governing document of the charity if it is in the best interest of the charity to do so. Some common examples of when this would be a good idea is if your charity's purposes aren't a practical or appropriate way to meet the need it was set up for anymore. Your governing documents doesn't say who your charity trustees are or how they are appointed. Provisions explaining how you must run the charity, for example, how to arrange a meeting, are no longer relevant or practical to the organisation. It's up to the trustee to decide if the change is necessary and what it should be, but as a company secretary, you shouldn't be afraid to prod them and point out that a change is needed. A common sort of problem that we see is that an objects clause for an organisation limits its activities to within London. The organisation has grown substantially and they've decided to carry out activities nationally across the UK, and we would then have to amend the objects clause to enable that to happen. So we normally recommend that you have quite a broad objects clause to account for your activities into the future. So you've decided that you want to update your articles. Great. What changes need to be approved by the Commission? Well, if you're a company, you'll need to get the Commission to approve regulated alterations to the Articles of Association. The regulated alterations are any changes to the purposes of the charitable company, what happens to the property on winding up of the charity, and also any provisions relating to payments to trustees or connected persons to trustees. So basically the process is you log in online to your charity portal and you submit the changes to the clause along with answering the various Charity Commission's questions about the clause. They do change depending on which clause you are amending. Submit it online and wait for the Commission to come back to you. Hopefully they approve it and there's no further questions, but you never know. It currently takes about 30 working days for the Commission to get back to you. So you definitely want to start the process early if that's something that you're thinking of doing. When you get written consent from the Commission, you need to make sure that the members then agree by special resolution to make the changes. I'll come back to that in a moment. I just want to give another example where regulated alterations have gone wrong. So I recently advised a client who thought that they adopted articles in 2017. And when I had a look around Companies House and the Charity Commission, it didn't seem to be the case. So I did a bit more digging and found out from the Commission that they had put in an application to make regulated alterations to their articles. This was in fact rejected by the Commission. which meant that the alterations were invalid. But the company went along and had the meeting and filed the resolutions with Companies House. So this was quite complicated process to kind of work out and advise the client on, but it basically meant that we had to advise the client to pass a resolution of the members which confirmed that the previous changes to the articles were ineffective, and ratify the actions of the trustees since the adoption of these articles, and then prepare new articles for the client, as the articles that they should have been operating from were their articles on incorporation from 1950. So it was quite an old document that was out of date and not really working for their current governance arrangements. So the process for adopting amendments to the articles is you need to have the amendments agreed to as a special resolution. That is by at least 75% of the members present and voting at a general meeting, or by members who together hold at least 75% of voting rights by written resolution. Once you get the required number, you must send a signed copy of the resolution along with a PDF of your amended governing document to both the Commission and Companies House. So these are specific to the requirements for amending articles of association for a company. I haven't spoken about CIOs and unincorporated charities. That process is a little bit different. Okay, so the final thing I want to talk about today is trustee induction. Before I get into what's in your trustee induction pack, I just wanted to talk about eligibility of charity trustees. So a charitable company must have at least one director who is a natural person. There's no upper limit on age, but the person must have capacity. There is, however, a minimum that the person is at least 16 years at least 16 years of age. And a person cannot be a trustee if they have been automatically disqualified in any of the circumstances set out in Section 178 of the Charities Act, which includes things like unspent conviction, subject to bankruptcy proceedings, etc., or if the individual is subject to a disqualification order by the Commission. So as the company secretary, it's really important that checks are being carried out to ensure that the individuals who you're planning to appoint are not disqualified in any way. Failing to make these background inquiries may put the reputation, assets, or beneficiaries of the charity at risk if an individual appointed as a charity trustee proves to be disqualified from holding or unsuitable to hold that position. Another thing to be mindful of is certain qualifications in the governing document for the trustee. So the governing document might provide that the trustee also needs to be a resident in the local area or a specific religious denomination. So your role is to kind of go through and check that those things are being done as well. In terms of appointing a trustee that is not a British nationality or who lives abroad, that is allowed, but you should ensure that the majority of your trustees live in England or Wales, England and Wales. Eligibility declarations is kind of a bare minimum of how what you should be doing as a company secretary. You should be asking a prospective charity trustee to sign a declaration that they are not disqualified from acting or willing to act as a charity trustee. The Charity Commission has 2 examples of these declaration forms, which I recommend that you put in to your pack. The first one is the trustee declaration that you would sign on registering a new charity. And also there's another declaration that the Charity Commission has put out to check that individuals who already hold a charity trustee position are not disqualified. There are also searches that you can carry out online for free. So a search of the individual insolvency register, the register maintained by Companies House, which checks disqualified directors. The Commission also maintains a register of all persons who have been removed as a charity trustee, officer or employee of a charity by order of the Commission or the High Court, or are subject to any disqualification order. Moving on to conflicts of interest, charity trustees have a general duty to disclose any properly managed conflicts of interest. In addition, directors of charitable companies are subject to rules of conflicts of interest under the Companies Act. So on appointment, you should really be obtaining a standard form declaration of interest from the trustee. And then HMRC has some requirements as well. So the fit and proper persons test is basically in order to obtain and claim UK charity tax reliefs and exemptions, an organisation or a group of individuals must fall within the definition of charity for tax purposes. And one of the conditions is that the charity must meet to fall within the definition is the management condition, which is usually referred to as the fit and proper persons test. The purpose of this test is to ensure that the charity is not managed or controlled by individuals who present a risk to the charity's tax position. So HMRC has guidance on this point, and it's basically a non-exhaustive list of factors that they will consider. But what you really need to do is, again, download the declaration form from HMRC's website and get your new trustees to sign it. So once you've gone through all the eligibility requirements, what should go in the trustee induction pack? Good practice dictates that every trustee in every organisation should receive a thorough and well-administered induction before assuming their responsibility as a trustee. A good induction prepares a new trustee to be effective, supplying them with key information about the organisation, about the responsibilities of trusteeship. The pack should act as a basic guide and reference to the board for the new trustee, and they should be encouraged to keep the induction pack and use it as a reference point as they continue to serve on the board. The documents that should be in the pack can kind of broadly be broken into three different categories: governance, finance, and operations. So in terms of governance, the documents that you should be giving the trustee are the constitutional documents, the articles of association, the standing orders, the regulations, the bylaws, whatever documents you have in that respect. Copies of all governance policies of the organisation, so the trustee code of conduct, the conflicts of interest policy, details of any committees, subcommittees and working groups and their terms of reference, details of any other delegations, expenses policies, etc. It's also a good idea to give the trustee minutes and papers of the most recent trustee and committee meetings. This gives them an idea of what's kind of been the points of conversation. Generally recommend at least 3 meetings. Relevant Charity Commission guidance, we've already talked about that today, and in particular CC3, the essential trustee, what you need to know, should be something that's included in your induction pack. And then also HMRC's guidance on the fit and proper persons test, which I touched on before. In terms of finance, the documents that you're kind of looking at are the current strategic plan for the organisation, cash flow projection and budget, the most recent management accounts for the organisation, the last year's accounts and annual report. From an operations perspective, the pertinent sort of information is a brief summary of the history of the organisation. Some organisations have a very long history, and it's really important to get that into the trustee's mind when they're joining the board and making decisions. A list of kind of the current activities of the organisation and the mission statement if you have one. Copies of key publications, research documents and background material if that's relevant to your organisation. An organisational chart and full details and job descriptions for key staff and details of other staff. Contact details for all the other trustees, some biographies on the trustees, and results of the last skills audit. The list of upcoming events, including dates of trustee and subcommittee meetings, details of training and sources to support and further information available to the trustees. A subtle plug here, but the Russell-Cooke team does offer trustee training if anyone needs it. Procedures for trustee meetings, including when the papers are sent out, the location of the meeting, the duration of the meeting, how the trustee can raise issues for the board to consider at the meeting. So in terms of induction, from our experience, you basically get from the trustee a lot more value with the more time you put into properly inducting them into the organisation. So it is a very valuable step for you to take. Another thing to just consider, it's quite common nowadays to introduce a buddy system. So it would be pairing up a brand new trustee with a trustee on the board who has a bit more experience. This we find is quite good for a new trustee because they can ask questions directly of that particular trustee that they've been buddied up with, as opposed to going to the board and asking a question and being a bit shy about it. And that basically concludes everything I was going to talk to you about today. So I'll hand over to Sehenya to cover the next section.
Thanks, Alison. Okay. Well, hello everyone, I'm Sehenya Ransford. I'm a legal director in the charity team together with James and Alison. I particularly specialise in advising new charities and being established, as well as group restructurings of charities, mergers, incorporations, as well as advising in particular boards for disputes that might be occurring within the boards themselves or within the organisation, particularly membership organisations. I'm going to be covering a few aspects in relation to effective governance, and we've talked about good governance fundamentally meaning ensuring that you as a board and together with you in your role as company secretary ensure that the board acts in accordance with its obligations, not only in its constitution but also in relation to achieving its charitable objects, and also that you are acting in line with all the regulatory requirements of being a charity. So we're going to be looking at preparing for an AGM and common issues for membership organisations that we've come across in the years that we've been advising, as well as key themes in board issues, and touching on a couple of additional key governance policies. Obviously, Alison's mentioned most of the key policies that you should have in place, but there are a couple of others that are pretty much hot topics for the Charity Commission, which I just wanted to touch on. So first of all, prepare for an AGM. This will very much depend on your organisation. It will depend on the size of your organisation. Do you have a vast membership like the National Trust with millions of members? Or do you have a much smaller organisational membership, as James referred to, about having a foundation model where fundamentally your trustees are your members? You do need to look at your articles and see what it says in relation to AGMs. If your articles haven't been updated since 2006 Act came into place, which was over the course of 2008, then it probably still refers to you must hold an AGM or an AGM will be held. That's no longer a legal requirement, but if your articles haven't been updated, you do still need to adhere to that must and hold an AGM, and that's an AGM in every calendar year. So think about whether it's still appropriate for your organisation. And what happens at an AGM will very much, again, depend on what your articles say. If they're old style, they probably refer to adoption of the annual report and accounts at your AGM. It might also refer, and that might be a key ongoing issue, about dealing with the appointment or the election, rather, of new directors, trustees to the board. So do check what your articles say. That will set the agenda for your meeting. There's been a lot of changes regarding how you hold meetings. It used to be that you had to hold them in person, in a place, so like this, in a room, everyone had to turn up. During COVID time with the social distance regulations, a number of charities weren't able, and other organisations weren't able to hold membership meetings for the clear reasons of social distancing. So an Act of Parliament was raced through, the Corporate Insolvency and Governance Act, which allowed you to have electronic meetings, irrespective if your articles said you could or you couldn't. Those provisions within that Act have now obviously been withdrawn, with COVID supposedly being a thing of the past. So the reality is there are some charities out there who are still holding meetings virtually who shouldn't, because their articles don't say that they can. We do strongly recommend, if you've got a large membership organisation, that you do consider amending your articles to enable you to hold meetings virtually. It's obviously not only time effective for individuals, it's cost effective often for an organisation. In particular, I advise a charity charity which has over 65,000 members in the psychotherapy sector. And could you imagine trying to do that, in in-person meetings? So they're going back to the style of having virtual meetings, but also more often than not now having hybrid meetings. Hybrid meeting simply means that you have persons in the room, such as yourselves, but most people are potentially logging on via Zoom or via Teams, or with it's a very large-scale membership, they often use a third party like My Voice to be able to deal with all the IT and the electronic aspects regarding it. So check what your articles say in relation to holding virtual and hybrid meetings. You also need to consider alongside that about quorum and proxies. Now, quorum is simply the number of individuals that need to be in attendance at a meeting in order for it to be validly held. You may have had a large membership, you might have easily got 25, 30 members that you needed in order to meet your quorum requirements a few years ago. Membership may have dwindled, you may be struggling now to get that. Do you need to look at your quorum provisions and think about amending them, reducing them to make them more appropriate for your organisation as at today's date? Consider also about proxy voting. It used to be the case that you could only have proxy voting if it was actually in your articles, but now under the new provisions of the 2006 Act, you can have proxy voting. So what do we mean by proxy voting? It fundamentally means if I'm a member of an organisation, if I'm unable to attend the meeting for whatever reason, I can send somebody else in my place to not only vote at that meeting, but also to speak on my behalf at that meeting if I would like them to do so. So where you've got a large-scale membership, you would often have a default position in the proxy form that's sent to members that they would appoint the chair of the meeting to vote on their behalf. And they either say in the proxy form how they wish their votes to be cast, or they may leave it at the discretion of the chair. So do remember that if it's a large-scale organisation, you would want to have proxies also counting in relation to your quorum. So if I was attending electronically, do your articles allow you to attend that meeting and count towards the quorum if you're end of a Zoom call in relation to it? So check what it actually says. It won't count automatically. You do also have to consider how you're going to give notice to your members. Now, many people, when you look at your articles, the old style articles pre-2006 Act will often say 21 clear days for notice of an AGM. It's now just 14 clear days. If your articles haven't been updated, it's still 21 clear days. And what do we mean by clear? Clear simply means we exclude the day you send the notice out and you exclude the day of the actual meeting itself. So you're factoring in effect 2 additional days. Also, you need to consider what is deemed receipt of notice, and your articles will normally say, for example, that if you send it by first class post, it's only deemed to be received by your member 2 days later. So again, you're factoring in an extra 2 days. So don't fall foul of missing up on your calendar of when notices should go out. And it's really important that you get that right, because potentially otherwise the meeting is seen as being invalid. If members haven't been given full notice. Also consider now, do you want to send out potentially bulky documents, accounts, annual reports and accounts, etc. to your members? Would it be easier if you could send them by email to your members? You can do that as long as you've requested that consent from that individual member to communicate with them in that form, and they've agreed and said in writing that they're happy for you to send it to them by email. Alternatively, some larger organisations, so many of my clients will actually have the documents available on a certain section on the website for the organisation, and then they're sent login details which they can then check and see that the documents are all available there. Now, Alison mentioned obviously about needing a special resolution if you want to make any amendments to your articles. So some of you may be considering that you might need to update your articles. The typical place is when you'll then go to your AGM, you'll put forward a resolution to your members saying, that the articles are being updated to make them more compliant with charity law and company law as well as recommended practice. And so, as Alison mentioned, you need a 75% of those who vote need to vote in favour of the resolution. A standard provision regarding ordinary resolution is simply in relation to whether your directors are being appointed or elected by your members, and that's just a simple majority for an ordinary resolution. Do also remember about voting. Generally, it tends to be in a company limited by guarantee. Most charities will be 1 member, 1 vote. Where you've got people who are using proxies. So if I'm the chair of at your AGM and I've been given 5 proxies, by individuals to vote for a resolution and by 4 to vote against it, they wouldn't count on a show of hands. I'd only get 1 vote for and 1 vote against on a show of hands. But if you do a poll vote, which is simply a counted vote, where you sign a voting slip or a voting list, as a chair, I can then cast 5 votes for the resolution and 4 votes against. And so the proxy votes actually count and are useful. And that's only if you do a poll vote as opposed to a show of hands. Alison touched on written resolutions. Obviously, you wouldn't use them within an AGM itself, but an AGM, if you're not having a AGM, you could potentially, if you've got a much smaller membership, just simply use written resolutions if you need to make changes in between an AGM, for example, to your articles. It basically means you send out the document and at least 75% of your members, so it's a higher threshold in reality because it's not 75% of the votes cast, it's 75% of your members who need to signify their agreement to it if you're doing it by written resolution. I just thought it'd be helpful just to touch on some of the typical member issues that we often find. Particularly, this may not affect many of you here where you've got a larger membership, but often this arises where members try to raise resolutions at an AGM itself and put forward a resolution. This is not allowed. This is not basically, if your articles don't allow for it, which would be very unusual to allow for it, members can't simply put forward a resolution at the meeting itself. The reason being is obviously there are people who aren't attending or attending by proxy, and they won't have the ability to vote on that resolution if there's a new resolution suddenly raised at the meeting. Now, some of our larger clients, particularly where they've got a large membership organisation, they will then enable and have relevant provisions within their articles to enable members to potentially put forward resolutions. And those resolutions, however, need to be considered by the board, they need to be in an appropriate format, and they need to be accepted by the board to be put forward. But it's not a given right. It's only if you have relevant provisions within your articles, and it would be something which is relatively unusual. There is, however, a company law right under the Act whereby members who hold 5% of the voting rights, or rather basically 5% of your membership if it's every member has 1 vote. So 5% of the members could get together and they could put forward a resolution to be used at a meeting. But that's fundamentally, they're doing it in a 2-stage process. They're basically putting forward a request to the company which needs to follow a certain format in accordance with the Act, and requesting the company to call a general meeting, and they can say that in that general meeting they would like certain resolutions to be put forward. There are, obviously you can't put any resolution you'd like to put forward. It has to not be vexatious or frivolous, and it can't obviously be defamatory of any person, and similarly it can't be anything which would put the organisation in breach. So for example, any change to the objects, which potentially would mean that the charity is no longer seen as being charitable, or that the Charity Commission hasn't given its prior consent to. The reason why I mention this particular provision under the Act is that there's often this common misconception about votes of no confidence in a trustee or certain trustees or the board as a whole. To advise where potentially members are putting forward and saying that they're going to put forward a vote of no confidence. In reality, under company law, a vote of no confidence has no real legal standing or meaning. Even if 100% of the members vote and say they have no confidence in a trustee, it doesn't mean that that trustee has to stand down. I mean, you'd like to think they could read the writing on the wall and they would stand down themselves, but they are not obliged under company law to do that. If members wanted to get rid of a trustee, one way they could do it is using that section 303, which is to request a general meeting. But rather than referring to a vote of no confidence, what they should be saying is that they wish to, ordinary resolution, it's a simple majority only to remove somebody, to remove a trustee, and they would name the individual, to remove X, and potentially to appoint Y in their stead. We've seen a number of familiar, for us, board issues that can occur, particularly where you've got a very dominant chair. on your board. That may not be the case for any of you, but it does arise in many of our clients' situations. It need not be the chair. It could be another trustee who doesn't allow other individuals to speak up or have their turn, or is quite domineering in their attitude in the sessions and the board sessions, and people feel maybe potentially slightly concerned about speaking up or maybe inhibited to do so. At the end of the day, the board has to act collectively. That's one of the key duties of trustees, and they have a collective responsibility to the organisation to do that. And they need to consider whether they might need to remove that trustee from the board. You need to consider what your articles say. When we do new articles for a new charity, or when we're updating articles for organisations, we always encourage boards to include in there a provision whereby a high majority, so say 75% of the board, can remove a trustee if they are no longer acting in the best interests of the organisation. It's a very useful tool to use, because if you don't have that, you have to use the more convoluted Section 303 provisions of getting your membership to then try to remove that individual. A few years ago, James and I advised a medical charity where there was a trustee who was accused allegations of acting inappropriately with beneficiaries of this charity. The client came to us, they didn't have relevant provisions to remove them, and we then had to go through the more convoluted process under company law to remove them, because this individual didn't feel they needed to stand down. But eventually they were forced to stand down through using this process, and when they allegations were found in it. Do be also clear about the member's right to remove and replace a trustee. This is the same provision that you would use in this scenario. And also consider whether you need to, if you've got a very large board or you've got a lot of work within that board, are you going to potentially consider delegating to various committees? We've often seen where people are delegating, but they actually haven't got a power to delegate within their articles, or that they haven't got appropriate terms of reference. So standard committees that we often see, you've got an audit and risk committee potentially, you may have a fundraising committee or a marketing committee, depending on the area that you work in within the sector. But look at your terms of reference. Have they been updated? What do they say about how often meetings need to be held for those committee meetings? When are you going to report back to the board as to what's happening on those at those committee meetings? And who are the individuals that are made up of that committee? Do you need to have a minimum number of trustees, for example, on the actual committee? Check that they still work. People often refer to using chair's action, and often use it in a very loose way that we'll just use chair's action. This is an implication or an implicit right that they believe they have, that a chair can just do anything that needs to be done, that might need to be done in between two meetings, for example, to act in an emergency situation. Do check, have you actually got a chair's action is actually in relation to a scheme of delegation, either in the board minutes or in a separate scheme of delegation, where an actual right has been given to the chair to, for example, to act in an emergency to protect the assets or the reputation of the charity itself. Otherwise, a chair's action doesn't exist as a given right under the provisions of the law, and potentially that chair could be found to be liable if they do something which they didn't have authority to do. In any event, chair in taking any emergency action in between board meetings should always ensure that they report it back to the main board as a whole, and it's then confirmed by the board itself. Charity Governance Code, which James mentioned earlier, which is not produced by the Charity Commission but it's endorsed by the Charity Commission, is very keen to have and promotes an EDI agenda, equality, diversity and inclusion, not just within your board itself but within your organisation as a whole, to try and make it as inclusive as possible. This can raise a lot of difficulties for organisations, because you may struggle to find trustees to join your organisation, let alone to ensure that you're satisfying an EDI agenda. So it can be a very difficult set of agenda to try and fulfil. You also, alongside that, are trying to work out what your skills that you're needing. Do you need more people with financial experience? Do you need more people with marketing experience on your board? How are you going to get that diverse board? Where are you going to advertise in relation to getting new trustees onto your board? The Charity Commission is also keen on the concept of new blood. James mentioned about the sort of 3 terms of 3 years is pretty standard. And if you're doing anything more than that, where potentially a chair is staying on a trustee is staying on longer, the Charity Commission does say in its Charity Governance Code that you should have rigorous review as to why that individual is staying on for longer. Also, many charities might want to consider having lived experience. This could be, for example, I advise a number of charities where it helps individuals with visual impairment. So, for example, some of them on the board actually state a certain number or a ratio of the board, ideally, because you don't want to be it too fixed, will be individuals with visual impairment, so that they can bring their experience and what benefits to them are required by a charity. I wanted to highlight these 3 key governance policies, and the reason for this is that they have very much an area where the Charity Commission has been focusing on, particularly for the last couple of years, and it still seems to be focusing on them. This is alongside conflicts of interest and ensuring you've got an appropriate conflicts of interest policy. The 3 here that I've included are very much interlinked. It's safeguarding, it's complaints, and it's serious incident reporting. James touched on safeguarding earlier, but I just want to go into a bit more detail in relation to these. So safeguarding always used to be about protecting children and vulnerable adults, or adults at risks, as it's sometimes referred to. The Charity Commission fundamentally extended the definition of safeguarding. So safeguarding is no longer just about those 2 categories of individuals. It's about your beneficiaries, it's about your staff, it's about your volunteers. It's about anybody who potentially could come into contact with your organisation. So that could be for somebody turning up at one of your fundraising events. And is there a safeguarding issue that could take place there? Safeguarding, and I've referred to this guidance at the end of the slide deck as well as with some of the other guidance that we've referred to throughout this talk, so you can definitely have more detailed look at those. But safeguarding is very much about understanding what your organisation is going to do to protect all these individuals. This is your staff, your volunteers. So with staff, you might have, in relation to an anti-bullying policy, anti-discrimination policy, harassment policy, avoiding any form of harassment in any form. But safeguarding can arise because of physical abuse, emotional abuse, sexual exploitation. It can arise because of any breach of the protected characteristics under the Equality Act. So we're talking about sexual orientation, disability, religious belief. So it's really vast, and it's an area where many charities have fallen foul recently. Over the last couple of years, you've seen a lot of household names who've faced difficulties as a result of safeguarding, and have even had statutory inquiries opened on them, which are public information, by the Charity Commission. So for example, RSPCA, many of you would have seen in the press, particularly in 2021, there was a lot of allegations regarding bullying amongst staff members and by staff members. Unite survey said that 29% of staff felt they had been bullied, and 47% believed there was a pervading culture of bullying. It's quite difficult with your fundraising when you're getting splashed across the Daily Mail in relation to these type of events. So you do need to be careful. NCVO, National Council for Voluntary Organisation, a very well-known and respected charity in the sector. In 2021, an independent report found that there was wide-scale bullying and discrimination on grounds of gender, sexual orientation, and disability. So again, they've had to do a lot of work to try and improve their public image in relation to that. It obviously doesn't just happen in the charity sector. We've seen what's happened to Dominic Raab. We've seen the number of cases of bullying that you hear about just in the press. It's obviously been going on for a lot longer, but people are more vocal now, and I think there's more tendency for people to come forward if they feel that they are being bullied within an organisation. So the ways that you need to protect your organisation and protect your reputation is obviously to have an appropriate safeguarding policy in place. You also need to ensure that you have a clear complaints procedure. And this is a document that the Charity Commission, doesn't have to be long, a 2-page document, which basically sets out how a member of public, if they have an issue with your organisation, how they can complain, who do they email, when will they hear back from that person in relation to their potential complaint. And your complaints policy should be somewhere easily accessible on your website. We normally say to put it near your Contact Us on the website page, alongside your safeguarding policy. the annual board review is a really good way for the board to ensure, and this is obviously why it often falls onto a task of the company secretary, to check that these policies are in place, they're updated, and they're being reviewed by the board itself. And you need to ensure that you also are considering, do members of your staff know how to raise an issue or volunteer if they're unhappy with something that might be taking place, or if they witness something which is inappropriate. Whistleblowing reports have gone up by 34%. By the Charity Commission has been obtained whistleblowing reports from individuals. There's an electronic form and an email where they can any person can now, a worker or a trustee, can contact the Charity Commission, and they can even submit it anonymously in relation to anything where they think, for example, there's harm being done to beneficiaries or assets aren't being used in the appropriate way by the organisation. Do also be clear, as Alison mentioned, about your selection procedures and the eligibility criteria. Make sure that obviously you fall within the relevant criteria for recruitment, not only of trustees, but also of members of staff. Even the Charity Commission fell foul when they were looking for a new chair for the Charity Commission. They were about to consider appointing Martin Thomas. They then had to stop that due to there were then allegations arose about his time at Women for Women International, where there had been inappropriate behaviour or allegations of inappropriate behaviour by him, and he withdrew from the process, and Orlando Fraser is now the new chair of the Charity Commission. So be clear on your recruitment and your selection procedures. Do follow up on relevant references for individuals, and also think about your exit procedures. When people leave, be that members of staff or potentially trustees. So we've carried out interviews with trustees, exit interviews for trustees who are leaving larger organisations, to see if there's any way that we can identify if there's anything going wrong that has made that individual leave, particularly if they leave before the end of their term. It could be something as simple as they thought they would only have to do 2 days a month on trustee work, and it could be that they find that they're doing 4 days a month, and they just can't cope with that alongside everything else that they're doing. So it's really worth talking to people when they leave. Also, when a number of staff are leaving from a particular department within a larger organisation, could there be potential bullying or an individual who making things a bit difficult for individuals in that organisation? James briefly touched on Royal National Institute of Blind People and the regulatory alert which was issued by the Charity Commission following their statutory inquiry on RNIB. So RNIB, very well-known charity, household name charity. Back in 2020, Charity Commission completed its statutory inquiry following closure of the Pears Centre, which was a residential home for children as well as a learning centre for children. And what happened at the centre was that there were serious safeguarding issues that arose. In fact, what happened was that some of the children hadn't been given appropriate medication, or the appropriate records weren't given in relation to those children. They had also used staff who hadn't been appropriately trained and were not qualified to undertake that job. In governance issues, they were also in relation to delegation to committees who were unaware of the tasks involved and were seen as being woefully inadequate by the Charity Commission. As a result of that closure of that statutory inquiry, that's when the Charity Commission issued this alert to the larger charities with over a 9 million income. But they did say that it was appropriate, this alert, for any charity working in the sector. And I think when a large organisation like RNIB falls foul, then you realise that there are a number of issues that could affect the reputation of your organisation. Fundamentally, with safeguarding, what you're trying to do is create a culture of speaking up, not only amongst your workers, staff members, consultants who might be working with your organisation, but also amongst your trustees, so that people feel that they can say if there's something incorrect, and it can be corrected within the organisation itself before it's a reputational issue. This is just an extract from the Charity Commission guidance. Again, this is included in your pack. And so I do suggest that you have a more detailed look at that when you can probably read it more easily than you can on the screen here. Finally, I just wanted to touch on serious incident reporting. This is another area where the Charity Commission believes that there's still significant underreporting of serious incidents to the Charity Commission. Now, just to remind people what a serious incident is. A serious incident is an adverse event, actual or alleged, which results in or risks significant harm to the charity's beneficiaries, to the staff, to the volunteers, to anyone who comes into contact with the Charity Commission. So there you can clearly see the link back to the whole safeguarding concept, and that's why these two are often seen as together. You also need to consider if there's going to be loss of money or to the assets of the organisation, or damage to the charity's property. This could be something through, for example, a burst pipe that causes flood damage in one of your offices, or harm to the charity's work or reputation. There should be no shame in reporting a serious incident to the Charity Commission. The Charity Commission will fundamentally see this as being good risk management, that the board is looking at it, identifying a risk and then dealing with it appropriately. This will often be a task that's obviously delegated. It's to the whole board is responsible. It's the board who has to sign off on the annual return to the Commission to say they are not aware of any serious incident that has taken place in the previous year that has not been reported. So it is important, if you're a company secretary or company secretary / trustee, that you remind the board of the importance of always thinking, should we potentially reporting an incident that took place. We often advise charities in relation to reporting serious incidents. Serious incident can happen through no fault of an organisation. I advised an organisation where they were sending confidential papers in relation to qualification of members and their categorisation within the organisation. The courier van that was carrying the papers got broken into, the papers got stolen. Obviously we had to make a report to the Information Commission's officer because obviously it's a data breach, and also to the Charity Commission. Other times we've been involved where, for example, bank accounts have been closed incorrectly during time when especially banks couldn't get hold of individuals, kept sending repeat letters, and then the funds from the account went to the Crown, and we had to then get the funds back. Clearly a serious incident if you can't pay your members of staff with payroll. Other times where it could happen is if a number of individuals leave an organisation, that's both staff, or if you get a series of resignations of your trustees for any particular reason and the board can't function going forward. I do advise you to look at the serious incident reporting guidance. It's really helpful. It gives a table of examples of what the Commission would say, yes, you should report, or no, you really shouldn't report. It tends to be whenever we've reported, they just tend to write back saying, thank you for letting us know. It's an online form that gets completed and submitted. It must always be submitted once the board has approved the submission, because obviously the Charity Commission could potentially, on getting a serious incident report, make further investigations into your organisation to try and clarify what's going on. But it's very much that the Commission believes there's still significant underreporting. And if the Charity Commission sees that there are two charities in a particular sector of the charity sector, and say, for example, rehabilitation of offenders, I advise a number of charities in that area. Most of those do tend to submit serious incidents reports almost on a monthly basis, because they run hostels with individuals who have substance abuse issues and other mental health illness, etc. And so there can be incidents that take place within the organisation. So they might be submitting serious incident reports to the Charity Commission more regularly than, say, a grant-making charity. But if there's another charity in the same rehabilitation sector which hasn't submitted a serious incident report in 2 years or 3 years, the Commission might take that as, are they just very lucky and nothing untoward is happening, or are they failing to understand the necessity to report it? So what we need to ensure is that you do have a relevant a serious incident reporting policy, in place. The importance of having it is that if the Charity Commission, which seems to be very hot on looking at all social media that's out there, or if parliamentary questions are raised in respect of a particular charity, they look at the information that's provided and they'll say, well, why did you not produce a serious incident report to the Charity Commission? If you don't even have a serious incident reporting policy, it's not going to look good. But if you actually have a policy, you've considered the situation, you've discussed it at board level, and you've recorded in your board minutes that despite the situation, you recognise there might be an issue, but you don't believe it's a serious incident at this stage and therefore not being reported, the Commission will then feel a lot more comfortable that you're obviously dealing with serious incidents or potential risks within your organisation appropriately. So do check if you actually got a policy in place in relation to this. And then, as I mentioned, we've included here various guidance taken from the Charity Commission website in particular. You will get sent a copy of the slides by our marketing team that will probably come to you later this week. And so hopefully the links will all work and you'll be able to just click in and see this. But if not, for any reason, do just pop that information there into Google and you'll find it on the Charity Commission website fundamentally. Anyone for anything else? Or you can grab us over a drink if that might be easier. All good?